Hello friends, welcome to Sathi, your partner in education. In this video, we will be discussing the basic concepts under family law, international law and intellectual property rights. So these concepts will be discussed briefly with relation to the legal reasoning part you require for all the law entrance exams. Let's start with the family law. First is Hindu marriage. What is marriage? For Hindus, marriage is very sacrament thing, very religious thing, and it's not in the form of contract, but it's a very religious and sacrament thing for Hindus. In India, Hindu marriage is dealt under the Hindu Marriage Act 1955, and it codifies the ancient Shastric laws of marriage under in the form of an act. So it provides for all the provisions and the ways by which Hindu marriage can be conducted. So it is given in the form of the Hindu Marriage Act, lays down the legal provisions governing the Hindu marriage and divorce also. The requirements of valid Hindu marriage and who is a Hindu is also explained under the Hindu Marriage Act. It's a very extensive act which provides for all the provisions which are required to understand the validity and requirements for a valid Hindu marriage. So, the necessary requirements of Hindu marriage are the customary rites and rituals. For example, Saptapadi. Like you must have seen that for Hindu marriages there has to be Saptapadi around the religious fire, wherein you take vows for your spouse. So Saptapadi is one of the customary rites which has to be which has to be done for the Hindu marriage or any other custom which is followed for certain time of years. So those customs must be fulfilled to validate the Hindu marriage. It could be exchanging garlands or Saptapadi or any other thing. Under the law, bigamy is outlawed, which means no person can have a subsisting valid marriage with any other person. That is, one person can have one valid Hindu marriage under the Hindu Marriage Act. So, any person who had more than one marriages before 1955, those marriages are valid, but after 1955, any Hindu can only have one legally valid marriage. Competency of parties is also discussed, that is age and all, that what is the valid age under which a person can get married. It's a very complicated matter, complicated provision under Hindu Marriage Act, so we would not go into those details, because in Hindu marriage law, even marriages of minors are valid if they ratify their marriage after attaining the age of 15 or 18 years. So it's a very complicated thing, so we will not enter into the complications of age of a marriage. And mental capacity of a person is also seen while deciding the competency of the parties to marriage. Prohibited degrees of relationship, or spinda relationship as we say in Hindu law. You're not allowed to marry between those relationships which are close. The women or men could be your relatives by way of being your father or uncles or brothers or sisters or aunts or grandparents. In those cases, it's called the prohibited degrees of relationship, and you're not allowed to marry with those persons. Other than Hindu Marriage Act, there is a Special Marriage Act which is applicable to all the citizens of India, not only Hindus. It's basically a contract civil marriage. All the citizens, including Hindus, can get married under Special Marriage Act. So religion of the parties is immaterial except certain prohibitions, like you cannot marry your sister or brother. So in that case, these are the restrictions which are given. Special Marriage Act is a very secular kind of act where all the citizens of India can get married. So similarly, we have different special marriage laws for Christians and Parsis, and Muslim marriages are dealt under the Muslim law, which we will be discussing at a later stage. So how divorce is dealt under divorce here, section 13 is given, section 13 of Hindu Marriage Act. So how divorce is dealt under Hindu Marriage Act is, there are various grounds of divorce on basis of which you can claim divorce from your spouse. So these are the grounds which are available to both the spouses, that is wife and husband. First is adultery, when you enter into any kind of intimate relationship with any other person other than your spouse, that is adultery. Cruelty is when you are being cruel, either physically or in a mental harassing way. In those cases, it can be a ground for divorce. So cruelty is available to both the parties. In certain cases, even denying your husband to have a sexual relationship is also amounting to cruelty. So cruelty is a very wide concept which the court has to decide on basis on the circumstances before the court. Desertion, wherein your spouse deserts you and is not with you for like 2 years. So in those cases, it can be a ground for divorce. This is required because if you are being deserted by your spouse and you want to enter into a new marriage, so in that case, you would have to approach the court for the case of desertion as a ground of divorce, and then only after getting divorce you can get married again. Next is conversion, when your husband ceases to be a Hindu or your wife ceases to be a Hindu or converts into any other religion, that can be a ground for divorce. If you wish to continue your marriage, even if your spouse has ceased to be a Hindu, in that case, you're allowed to, but this is a available ground for divorce. For example, your wife or husband converts into being Mohammedan, so in that case, you can take a divorce from your spouse. Incurable unsound mind or mental disorder, if your spouse is of such condition, this is a ground for divorce. Another is virulent and incurable leprosy, if your spouse is a leprosy, this is a ground for divorce. Venereal disease of communicable form, so this is also ground for divorce. Renounce the word, if your husband or wife has renounced the word or enter into a religious order has become a sant or mahatma, in that case you are allowed to take divorce from that person. You have not heard of your spouse being alive for 7 years or more. So desertion is different and this clause is different. In this case, you do not know whether your spouse is alive or not. You have not heard it from anybody in any way that your spouse is alive. In that case, it's a ground of divorce. In desertion, you know that your spouse is alive and that person has deserted you. They do not wish to cohabitate with you and do not want to continue their marriage. So in that case, it's a ground for divorce, and in this case the spouse is known where that person is living. However, the other categories wherein you have not heard of your spouse being alive for 7 years or more, in that case you can approach the court and court would give you divorce ex parte, that is in the absence of the other party. So these are the grounds which are available only to the wife. First is husband found guilty of sodomy, rape, and bestiality. Rape, sodomy and bestiality are unnatural ways of sexual relationships. So when your husband is found guilty of any of these crimes, this is a ground of divorce to the wife. Other technical grounds: no resumption of cohabitation after 1 year of decree of judicial separation or maintenance. When you have obtained a decree of judicial separation and you do not cohabitate within the 1 year time of that decree, in that case it's a ground of divorce. Next is we discuss Islamic laws on marriage and divorce. What is marriage under Islamic law? It's called nikah. As we all know, it's in the form of contract. It's a pure form of contract wherein there's a mutual contract between a man and woman and they agree to enjoy each other's company and start their family in the sound society. So it's a Hindu marriage is not in the form of contract. So the difference between Hindu marriage and Muslim marriage is that Muslim marriage is in the form of contract. There's a actual agreement written and parties sign that agreement. So the agreement is given in the form of contract to the parties, that is man and woman. Next is meher. Meher is the consideration for the contract. Like we discussed in the contract law, that for a contract to be valid, there has to be a consideration. In case of Muslim marriages, meher is given as a consideration. This meher is given by the bridegroom to the bride as a consideration of marriage. The basic concept which lies in here is that man agrees to pay certain amount in the form of meher to the wife by exchanging that I will use or enjoy your company as under the contract of marriage. So this is the consideration given to the bride by bridegroom. Next is divorce or talaq. There are various forms of dissolution of marriage under Muslim law. Basically, all these rights of initiating divorce are given to wife in most cases. There are only one or two types of divorces where wife is given the right to pronounce, divorce. So it's not basically a mutual agreement thing. In certain cases, there's a concept called triple talaq, wherein a man can actually pronounce talaq thrice, and it would result into the divorce between the husband and wife. So there could be various way of resolution of marriage. It could be either by husband or by wife, or by mutual agreement, or by judicial process, which is available to all the citizens of India. So basically, most of the types are initiated by the husband. Next is iddat. In Islam, iddat means period of waiting. Whenever a man divorces a woman cannot marry another man for the period of 3 months. The iddat period is for 3 months or 3 lunar months. Lunar months means when she had her 3 cycles, 3 monthly cycles. So it could be 3 months or 3 lunar months. This is basically the period is basically given for sake of the child who might have been conceived by the woman during their marriage. So it would make it easier to decide who is the father of that child. So iddat period actually is for the safety of the child who would be born out of the wedlock of the couple who's getting divorced. So if during those 3 periods the woman is not pregnant, in that case she can marry the other person after the 3 months or 3 lunar months. The concept of domestic violence is dealt under the Domestic Violence Act 2005. There was a provision of Section 498A under Indian Penal Code, which is inserted in 1983. It's basically a protection to the woman given against the cruelties by husband or his family members. However, under Domestic Violence Act, it provides protection to women who are legally married, but also those who are in live-in relationship, women who are sisters, widows, or mother, or also divorcees. So it has given the protection to all the categories of women by who will be protected against the offenses or force or any kind of violence against them by the family members. The offenses are cognizable and non-bailable. So you would have understood the meaning of cognizable and non-bailable by now. So cognizable is when the case is taken by the judicial magistrate, and when the arrests can be made by the police, and it's a non-bailable offense wherein bail is not given to the offender. The question comes to a mind that can a wife be cruel to her husband? Yes, wife can be cruel. You can read the case of Dastane versus Dastane. It's a very old case. Dastane versus Dastane, wherein a woman used to torture her husband. She used to beat him, she used to abuse him and his family members. It was a reverse case of violence. So yes, a woman can also be cruel to her husband. However, a man or husband is not given protection under Domestic Violence Act. So yes, she can be cruel, but the Domestic Violence Act does not provide any protection to men. The punishment can be the imprisonment up to 3 years under Domestic Violence Act with fine. The complaint of cruelty need not to be lodged by the person herself. That is, women herself can, or she, even anybody on behalf of that woman can approach the court with the complaint or the police with the complaint. So there's no need for her to go herself. In certain cases, executive magistrate can actually ask the person to execute a bond, that is bond to keep peace or bond of good behavior, wherein husband is put to stop the domestic violence by giving the bonds. After family law, we will approach further to the international law. International law, you have to read only for the basics. It's a very rare there would be questions on international law. However, for the sake of covering the topic, we will discuss the basics of international law. The Statute of International Court of Justice provides for certain provisions as to the principles of international law, because there is no codification of international law done, and there is no international acceptance of any kind of treaties or anything or any statute. However, for sake of studying, we can study the Statute of International Court of Justice. Article 38, Clause 1 provides for the sources of international law, as to what are the sources of the law. For example, in India, we have laws, statutes, and acts passed by the Parliament of India. So, for international law, what would be the sources? First is international conventions, whether general or particular, established rule expressly recognized by contesting states. You must have read or heard that there are conventions which like human rights convention or any convention or particular topic or general conventions, wherein states participate and recognize those conventions, and the principles of that conventions are recognized by those participating states. So those conventions form the basic part of the source of international law. Next is international custom. It has to be a custom that is being followed by from certain period of time, and it's a general practice which is followed around the world and accepted by the law. So customs actually termed as the law when they are accepted by the international fraternity. General principles of law recognized by nations. These are basically natural law or general principles of law which are recognized by most civilized nations. These also form the principles of sources of international law. Judicial decisions and teachings of most highly qualified publicists of various nations as subsidiary means of determination of rule of law. Judicial decisions and teachings, like for example, International Court of Justice or International Criminal Court provide for certain decisions. In those cases, those decisions can also form the source of international law. Article 59 says that decisions of International Court of Justice are not binding decisions. These have persuasive value, but these are not binding ones. That the courts are not bound by the decisions of International Court of Justice. Next is, what is force? Why we need to understand force? Whenever we take any kind of action against the other state, so we use certain kind of force. So we will discuss two kinds of force which is used by states generally to retaliate the injurious acts by other states. So this slide provides for the kind of force used by the states. It could be military, political, economic, or any form of coercion against the political independence or territorial integrity of state. So what is the force? It's any kind of coercion against the political independence and territorial integrity of the state. What are the categories of force? First is retortion, adoption by one state of hostile act nevertheless lawful as measure of retaliation against the injurious acts of other state. So when one state resorts or opts for any hostile act which is lawful against as a retaliation against the injurious acts of another state. For example, swearance of diplomatic ties or travel restrictions. Whenever any, for example, A state has taken certain injurious acts against B, B in turn does not, returns that injurious acts to the state A. However, what it does is it puts travel restrictions or swears all the diplomatic ties between them. So in that case, they do not do the similar thing, but they take the hostile act against the state A. There are travel restriction put on the citizens of state B that you cannot travel to this state, or any kind of you know trade would not occur between these states. So these are the kinds of actions which are taken by nature of retortion. Next is reprisal. This is adoption by one state of illegal acts in retaliation to the illegal acts. In contravention to this concept, in this case, B would take actually similar kind of injurious acts in retaliation to the acts done by A. So examples could be breaking of ceasefire agreement by one state in reprisal to the ceasefire violation by another state. For example, A breaks the ceasefire, B would also do the similar thing. So one is taking hostile act which is lawful and other is taking illegal act in retaliation to illegal act. So these are the kinds of force which could be used by the states. Whether force is used is legal or not, general rule is that there should be no intervention. It's a part of customary international law and found on the concept of the territorial sovereignty, that it says that you cannot intervene with the territorial sovereignty of the other state, and the intervention is not allowed. The exception to this rule is humanitarian intervention. When any state in intervenes into the strategic or any national interest of the other state, which is motivated by the humanitarian objectives. For example, if you want to save the citizens from the internal armed rebellion within the state and you intervene with the provisions of that state, that would be humanitarian intervention. What are the ingredients of humanitarian intervention? You can read it out. One is involves the threat and use of military forces as a central feature. Threat that may or may not be followed by the use of military force. That there is a threat of military force interfering in the internal affairs of state by sending military forces into the territory. So this intervention would be by sending the military force in response to a situation that does not necessarily pose a direct threat to intervening states' strategic interest, that is motivated by humanitarian objectives. So there is a threat as in of use of military forces, and the intervention is done into the internal affairs. However, the most important aspect of humanitarian intervention is that it is motivated by humanitarian objectives. So this is the fundamental concept underlying the humanitarian intervention. Let's understand the basic concepts under the international law. First is treaty. It's a agreement between the two states wherein those two agree to form certain treaty and agreement, and it's a binding international law. It can be between two states or more than two states, concluded by the international entities. Ratify or ratification. This is the word used when a state signifies an agreement which is to be legally bound. The state agrees to, or ratify would actually in layman language would mean accept or sign it. Whenever you sign the international legislative requirements, so it would be ratification. To ratify a treaty, state first signs it and then fulfills its own national legislative requirements and incorporates the treaty into domestic legislation. For example, if you sign international human rights treaty, any kind of human rights treaty, then you first of all sign it and then you take the provisions of that international human rights treaty into the national laws. Right. For example, any international human rights treaty provides for the protection of child against the sexual abuse by the relatives. So such provisions, if you sign that treaty, such provisions are to be included into your domestic legislation. It would amount to ratification of that treaty. That is, you have accepted and signed the agreement that is legally bound on you. Next is recognition. State recognition signifies the decision of sovereign state to treat another entity as also being a sovereign state. Like one state, that is one country, recognizes another country to be a sovereign entity. So this means recognition. It can be expressed or implied, and it's actually in most cases retroactive in its effect. That is, from the previous time that the state has been there for certain period of time. It does not necessarily signifies a desire to establish or maintain diplomatic relations. So it would not actually mean that you want to establish any kind of diplomatic relation or maintain such relations. It is merely a recognition of another sovereign state. Extradition, you must have heard this word in various news items wherein criminals are involved. So let's understand what extradition means. When someone is extradited, usually he or she is surrendered by the government of one country to the auspices of second nation that petitions this surrender. This second nation has the authority to prosecute the individual according to the criminal law based on the fact that crime was committed within its boundaries. In most extradition requests, the two concerned countries should have signed extradition treaty, otherwise the concerned individual may not be extradited. For example, there are two countries involved, A and B. This person X who has committed certain crime in country B. However, this person is living in country A, right? So B can actually request A to extradite the person X because B has the right to convict this person under the law because the crime was committed in country B. However, for making that request, there must have been any kind of extradition treaty between A and B. If there is no extradition treaty, B cannot request A to extradite person X. However, if there is extradition treaty, B can request A to send this person X to B so that they can prosecute for the crimes or offenses committed in the territories of country B. So this is the basic concept of extradition. Next is exclusive economic zone. This actually relates to the maritime zone that is adjacent to the territorial sea and which will not extend beyond 200 nautical miles. It provides that under exclusive economic zone, the coastal state has the right to do any kind of exploring, exploiting, conserving or managing natural resources of any kind or any activities of economic exploitation or exploration of the zone. So this gives exclusive right to the coastal state for any kind of economic exploration of the resources, whether natural, living or non-living. So the concept of exclusive economic zone is right given to the coastal states. Next is monist state. Monist state assumes that internal and international legal systems form a unity. So these kinds of states are rarely there who actually believe that internal legal system should be similar. Whatever the international rules are there, state accepts them as it is by way of treaty or any other way. So in this case, the international law actually becomes the internal law also. So monist states are the ones who form the unity between internal and international law together. Next is dualist states. In contravention to monist states, dualist states are ones who differentiate between the national and international law. What they do is they ratify certain international laws and then they incorporate the provisions of those international laws into their national law. Whatever they do not ratify would not form the part of their national law. So there are two kinds of laws for dualist states. First is national, second is international. They may or may not accept the international law as their national law, unlike monist states. Next is what is International Court of Justice? It's a dispute settlement body which adjudicates upon the disputes amongst the nations on the questions of public international law. It is situated in Hague, Netherlands, and it's a successor of Permanent Court of International Justice. It's formally established in Hague. Next is International Criminal Court. What does it do? It adjudicates the cases related to genocide, war crime, crimes against humanity and crimes of aggression, right? So this is the successor to various tribunals which were formed, for example Nuremberg War Crime Tribunal, International Crimes Tribunal and former Yugoslavia. It's next is the International Crimes Tribunal for Rwanda. You must have heard the massacre in Rwanda. It's a internationally famous genocide wherein thousands or in fact lakhs of people were killed in Rwanda. So there was a tribunal, International Crimes Tribunal for Rwanda. So the International Criminal Court is a successor to all the tribunals. So it has the right to adjudicate upon the offenses of genocide, war crimes, crimes against humanity and crimes of aggression. So these are the two international codes which are famous for their adjudication. After discussing the international law, we will go into the intellectual property laws, and we will discuss the basic concepts very briefly. Patents and copyrights. What is a patent? Patent is an exclusive right granted for an invention which is a product or a process. So it could be a process patent or a product patent. In general, a new way of doing something or offers a new technical solution to a problem. So whenever you invent something new, that is, you invent some new product or some new way of doing certain thing, it would amount to patent. In India, it is governed under the Patents Act 1970, which is amended thrice. A patent is granted to inventor for a patentable invention for manufacture or sale of the article. The patentee can actually is the only person who has the right to sell and manufacture that article, or he can assign that right to somebody. The controller of patent grants the patent for 20 years. You get the patent for certain invention for the period of 20 years. Next is copyright. Copyright and related rights protect the rights of authors, performers, producers, broadcasters over their work. For example, books and songs and music tracks and all those kinds of things are protected as a copyright. The purpose of copyright is twofold: to encourage the dynamic creative culture while returning value to the creators so that they can lead the dignified economic existence. Whenever somebody writes a song and that song is given the copyright, in that case they can exploit that copyright economically by selling the songs to the the recording centers, to provide the widespread and affordable access to the content for public. So these are the two motives under copyright. In India, the Copyright Act 1957 governs it, and the author of literary, dramatic, musical, artistic work has the exclusive right of reproduction of such work. Mostly, which are the book writers or the songwriters or singers are given such rights, and those are the only persons who have exclusive right to reproduce such works. For example, reprinting the books, and the person would be given the premium for the books reprinted. The author would be given the premium. In that way, he actually exploits the copyright in an economic way. The right continues after the 60 years after the death of the author. Right, so the right is very long. The permissible copy of some material is allowed for the purposes of research, criticism, or review, or for educational purposes. It's called fair use. In certain cases, the copy of such material is allowed, and it's called the fair use. Next is trademark. Trademarks are the distinctive signs used to differentiate between the identical or similar goods and services offered by the different producers or service providers. Trademarks are a type of industrial property protected by the intellectual property rights. The Trademarks Act 1999 provides for the trademarks. The signs which you are seeing, like for the Jaguar or McDonald's or Motorola or this one, these are the trademarks which differentiate the cars. For example, in case of Jaguar, the Jaguar cars are differentiated from other cars by way of this trademark. Similarly, the McDonald's burger would be differentiated from other burgers by way of this trademark. So the value which you are giving, the price which you are paying for the burgers, is actually more than the cost. The value which you are paying more than the cost is the value of the trademarks, the value they have earned by way of their reputation. So the trademark would differentiate the certain brand from other brand, which are the similar. The definition says that it's used to differentiate between the identical or similar goods. There could be other person who would be making burgers or cars similar to the Jaguar or McDonald's. In that case, the brand name or this trademark would differentiate it from the other burgers. So the Trademarks Act 1999 provides it may be a mark, a brand, a heading, a label, a name connected with the name of business. So the trademark is registered for the for the period of 10 years, and it can be renewed under Trademarks Act 1999. There's an offense of passing off which is given under the Trademarks Act, wherein action would lie when a person uses trademark in an unauthorized manner. Whenever you use, for example, a roadside vendor uses this trademark of McDonald's for passing off his products. So in that case, it's an offense of passing off, wherein McDonald's can actually sue that person for passing off their trademark. Next is geographical indication. Geographical indication is a sign used on goods that have a specific geographical origin and pose qualities, reputation, or characteristics that are essentially attributable to that origin. The examples would make you understand the concept of geographical indication easier. For example, you must have heard of Darjeeling tea. Darjeeling tea poses the qualities of certain kind which are attributable to the area of Darjeeling only. That's why it's called Darjeeling tea. Similarly, if you say basmati rice, there was a case of basmati rice wherein there was a kind of rice which was produced in England, I guess. So in that case, India had actually taken up the case of geographical indication, saying that basmati rice has the origin in India. So India should be given the geographical indication for the basmati rice. So this is so basically geographical indication is the concept wherein you get the protection for kind of the goods produced in certain region, and there are certain qualities which are attached to that which are attached to that product by way of its origin. So these are the other examples, like Scotch, the geographical indication is given to Scotland. Irish whiskey, the GI is given to Ireland. So GIs are protected in accordance with the international treaties as well as in national laws. There is a Geographical Indication Act also. Trademark laws also form in the form of collective marks or certification marks can also be recognized as geographical indications. So this is the very different concept. So thank you so much for being with us.